Chile has filed another motion, but I've had to go back through the docket to see the docket entry that he refers to in the motion. And it's a transcript of an emergency status conference requested by Wish, but not held in front of Judge Burrows, but in front of Judge Saris. And prior to reading Chile's motion, I just note on page 5 of the transcript of that hearing, Judge Saris refers to emails received from Wish and another gentleman, who I believe was Mr. Todd Lyons. Right, let's look at the motion he's filed today. So it's plaintiff's motion for disclosure. Plaintiff Jose de Castro hereby moves this honourable court to disclose 1. All ex parte communications concerning this action. 2. Any personal bias or prejudice that this court has against plaintiff. And 3. The answers to 2 questions below. Is Judge Burrows a member of any law enforcement / police associations, brackets including any and all contributions and awards? 2. What does Judge Burrows know about plaintiff in addition to the record for this action? In support of this motion, plaintiff submits a memorandum of law, which is fully incorporated herein. Facts. The court's order at ECF 47 states, the court will not communicate with any party to this litigation ex parte, nor will it accept ex parte communications. Any communication received from a party to this litigation will be placed on the public record. The transcript of the hearing at ECF number 22 mentions communications from Todd Lyon to the court. Due to these facts, this is not a baseless fishing expedition, but rather backed by evidence of the existence of ex parte communication that plaintiff has not been party to, nor are these communications part of the record, nor has plaintiff been able to respond to these communications. Points and authorities. Pursuant to Code of Conduct for United States Judges Canon 3, brackets A, brackets 4, brackets 2019, a judge should accord to every person who has a legal interest in a proceeding, and that person's lawyer, the full right to be heard according to law. Except as set out below, a judge should not initiate, permit, or consider ex parte communications, or consider other communications concerning a pending or impending matter that are made outside the presence of the parties or their lawyers. If a judge receives an unauthorised ex parte communication bearing on the substance of a matter, the judge should promptly notify the parties of the subject matter of the communication and allow the parties an opportunity to respond if requested. A judge must make disclosure on the record of circumstances that may give rise to a reasonable question about his impartiality. See, and there's a court reference there, and then a declaration. I will just add a bit of commentary here at the end. It's not clear whether Judge Burrows herself read the emails that were referred to in 22, but the fact that they exist was disclosed by the emergency judge. The emails are not part of the record as they are ex parte communications. But a court doesn't err by receiving communications from a third party. In essence, there's nothing they can do about it because any third party can send in anything to a court. It's whether they then are considered. And then we go on to the second part of his requests. I don't know what number we're up to in the book of how to piss off a judge, but his obvious question of her impartiality due to alleged association with law enforcement and other knowledge that she may have of Chile de Castro are sure to piss off the judge. I'm not sure it should be signed respectively submitted. However, perhaps you're a see you next Tuesday, Judge Burrows. Thanks for watching.